So today is yesterday's topic, that is absolute liability. What is the usual difference between strict liability and absolute liability? Any one of you all? Okay, so
Can be made, whereas in absolute liability, only an enterprise can be made liable.
what?
In
Bit
strict
loud?
liability, sir, is it audible?
Yeah, now it's audible.
Sir, the difference between strict liability and absolute, in strict liability, any person can made liable, whereas in absolute, only an enterprise can made liable.
Okay, but in that is, yeah. Yes, go ahead. Commercial activity, that is for profits, there was a special enactment, special law which has been enacted by the parliament, realizing that uh, they wanted to bring the strict liability into for a remedy, for to give some sort of remedy. So made a uh, Public Liability Insurance Act in after the Bhopal gas leak case. So to give some sort of remedy, because see, with such big incidents occur, if they society, within a society, then there will be a lot of confusion.
The enterprise which is like dealing with commercial objective is held liable in
Yes,
absolute
absolutely.
liability.
They have to, because they are earning profits out by
Illegal
keeping.
activity, is it?
No, no, not a legal activity. They are holding the dangerous thing. Whatever probably the dangerous thing in LG polymers, maybe because of certain gas or sterilite, some poisonous substance. The substance, whatever is the, which is harmful substance. Probably we underline, we can say that harmful substance. Okay, when
Okay,
it
sir.
is trying to harm some person, then there should be some sort of remedy. In strict liability, what is happening is every person taking an exception is trying to escape the liability. They are trying to escape the liability in probably the when they are performing their uh, that is some sort of they are being responsible for some sort of some
Act.
dangerous
Hmm.
activity
Yes.
or omission. Okay. So what is happening is due to these exceptions, that is probably they may escape as an inevitable accident or probably act of God or maybe a that is concerned, mutual concerned, plaintiff's own default. All such things are taking given as an exception when Supreme Court in their public social interest litigation it is a social interest when any person who is harming is being left out, left free, then they felt that that such is the situation which occurred during that Union Carbide Company, the Bhopal gas leak, where during their procedure of negotiations in the Supreme Court, the law there could be a gap in the law. So those loop they tried to escape, but because of that social interest, the society interest is at large. So they have to put forth, they brought the absolute liability. One more difference is that in strict liability, usually that hazardous object, the harmful substance, is within the premises, and when it escapes, the mistake is when it escapes from the premises, then the damage, then he will be at a fault. If the substance does not escape from the premises, strict liability has got a defense, no fault. You cannot make them liable. But in absolute liability, holding the hazardous, harmful object itself is when they are uh, resorting to some sort of, who is this? To some sort of uh, harm, then that harm itself is sufficient to attract absolute liability. Okay. So, yeah, who is this? Badri. Badri, so you cannot have permissions. హలో ఏమైంది ఏమైంది Forward. Today we are trying to look into the concept that is fault, fault liability. If you look at the fault liability, usually it is connected with negligence. Fault probably you will find in nuisance. Fault you also find in defamation. Fault you find in trespass. Trespass. What is trespass? Entering in force. See, there is criminal trespass. There is civil trespass. Okay. So entering someone's uh, land, when there is no such restriction, then probably you may have to take that to civil trespass. But when it is when you are causing certain kind of a harm, then see, entering a house, breaking the objects, probably they're breaking they're destroying the property, damaging the products. in the house, probably maybe a criminal trespass. Criminal trespass, okay, house breaking also probably. So those are the concepts. How see when certain things are restricted, it is a public wrong. When when they have remedy even in torts, yes, probably yes, you can avail that remedy. Okay, fault in passing off in the sense maybe some fraudulent representation. See, passing off in the sense I'll explain you where uh, mm, someone owns a product. I give a false image stating that that product is mine. Okay, I am at fault. I am not the original representative, but I am trying to make the replica that is false. Probably I may be a false owner of that product. You
Sir,
may some sort of
it comes into copyright also, sir.
probably not copyright. You will find the majority in trademarks.
Okay, sir.
Passing off, yes, you have a concept in copyright. I agree, but actually you see it in goods. Probably see that is in trademarks. Trademarks, absolutely yes, absolutely. We can say that. See, someone has got a trademark of some product, but I make a image. I built an image that is mine, a false representation, and I sell those products to the customers. I probably make a duplicate, something, some cause of damage to the owner of the trademark. I am harming, probably in the form of a reputation, probably in the form of theft, just, taking a replica of his image and selling those products in the market as if I am the actual owner. So that is a passing off. So it can be a damage to the goodwill. It can be a misrepresentation and damage to goods. Okay. Now we will go in depth about the concept that is fault. Because this is an economic activity. This is purely connected with some economic because uh, they consider that to be a kind of negligence because this fault liability is a economic aspect. It is dealing with purely an economic aspect. Okay, a negligent or intentional failure to act reasonably or according to the law or duty, an act or omission giving rise to a criminal indictment or civil torts. So this is kind of negligent or an intentional failure to act reasonably. Okay, what is reasonable care? Anyone?
Concern of safety.
Sorry, ma'am. Repeat again. I could not.
Concern for the safety.
Concern. Okay. Safety is also an aspect of security. Yes, absolutely right. You have given a dimension. Anyone else? Reasonable care. When I talk about health, some sort of reasonable care. I put it as a standard one.
Precaution, sir.
Sorry.
Precautions.
Precaution is okay. Reasonable precaution, probably yes, is a part of a reasonable care, health. Nowadays, pandemic is more, the precautions are to be taken reasonable, something which is logical. Okay. So whenever a person tries to, where he, where there is a failure, particularly to act proper, you may call it a good faith expression. Some admission issues I am filled up. Okay, so fault is some reasonable. Okay, good faith. Any breach of good faith. What is duty of care? So all these concepts come across some reasonableness, some sort of reasonableness. You find these words with some some sort of reasonable, that is good faith. In good faith, if you are looking in good faith, some person does not do any whatever is the duty which is upon him, then he is at fault. Okay, so that is probably a kind of fault. So there can be a tort of lawsuit. There can, you can sue him for torts. Okay, defendant torts must prove to have caused the loss suffered. So the key ingredient in this is there has to be what is that loss which he is suffering, that you have to clearly bring forth in your suit, in your lawsuit. You have to clearly establish. So fault is an essential ingredient of tort. So wherever you come across some kind of fault, okay, default. How do you measure this default? See, when some person has, you have to clearly first look at the duty of care. So what is that duty? Or to hold a person liable for torts, you have to examine whether he had any duty of care. Okay, so now let us move to negligence, some sort of negligence. Negligence, to prove the dependent's fault for liability is to establish that the defendant must be in breach of duty of care. So it is in negligence. What is the key ingredient? That is the breach of duty of care to the claimant. So whoever the plaintiff, whenever they are trying to raise a litigation, they have to clearly establish that there is a there was a duty of care, and that duty, there was some kind of non-performance in their duty. If you look at the case law which I have told you earlier, that is Donkey versus Stevenson. So see, I would bring forth the facts of this case where certain person, when he wanted to purchase a beer for his friend, then when he drank few, that is after consuming the beer, then he found a snail, the dead snail in that beer. So then he sued the product manufacturer. Now, how do you think that the product manufacturer is whose fault? So how do you think that the product manufacturer is at fault when He does not have any sort of re, any sort of relationship with the end client, because he gives to a retailer, retailer gives to wholesaler, wholesaler directly sells the product to the customer. So the wholesaler, there should be some sort of, there is some sort of
Relationship.
relationship between the wholesaler and the customer, but not with the manufacturer. So how do you bring forth this duty of care for that producer? Anyone?
Sir, providing a good products is a responsive total responsibility of manufacturer. Why? Because he is
Okay.
owning the name, sir.
Sir, it is
Okay, you mean to
absolute
say
liability, sir.
absolute liability? Yes, madam. Yes, please go ahead.
Sir, it is a law of negligence at the time. And in terms of absent a contract, a manufacturer was aware that the product was dangerous, and the product was dangerous, failed to warn
See,
the consumer of this.
okay. See here, duty of care. What is the duty of care? When he is like he's selling some food products, he has got a duty of care to the world, to the entire world. Wherever he's trying to sell his products, he should prove that the products are the best. Best, they don't do any harm. More, if they are not the best, probably they cannot be any sort of harmful substance, harm which causes, see, those those people, the beer contains some dead snail which could affect the health of a individual. He had a duty of care. Just a moment. Hello, sir. సార్ నేను ఇక్కడ క్లాస్లో ఉన్నాను సార్. చెప్పండి సార్. స్పాట్ మీకు 24th అని అనుకుంటున్నాను, 24 to 27. చూడండి, ఇంకా ఇంకా బాగా యాక్చువల్లీ ఏంటంటే ఆయన కన్వీనర్ గారు నోటిఫై చేస్తారు టిఎస్ లాస్ వెబ్సైట్. వాళ్ళ మనిషి వస్తారు, మనం ఏం చేయలేము. లేదు, నోటిఫై మన కన్వీనర్ చేస్తారు. 2000 కష్టం సార్, ఎందుకంటే సో okay, there is a duty of care, and to the entire world. When they are producting, there is a privity in contract, where they owe that whoever probably consumes the product, they have got some sort of duty of care, that is not to disturb the other, not to harm the other individual, especially when the manufacturer is bringing forth. So he in comparison with every product, individual product, did not contain that dead snail. It is only defective, some sort of mistake, some sort of defect that occurred in making that particular individual, that beer can, was the cause of concern. It was the cause of concern where there was some kind of negligence from their part. So this is the reasonableness, the reasonable care which the manufacturer should have taken was missing. So the negligence part is clearly established. The defendant must do something that a reasonable person would not do so, or omit to do something what a reasonable person would do. Okay, so this is the uh, prime aspect when there is a breach of duty of care. Okay, the failure to take reasonable steps to prevent causing harm to the person that a reasonable man would foresee him to put at risk. So here, because duty of care towards the other individual's health was the prime concern in this negligence. Okay. Now, moving forward, the next one is the nuisance. What do you term as nuisance?
Public road.
Activity which is harmful or offensive.
Okay. I will bring certain aspects. As Madam said,
As it
security,
affects the moral
safety,
community, safety
safety,
of the society.
security, then some sort of prohibition of a freedom. It can be in any form. Usually, when we some sort of disturbance, we find many occasions, marriage occasions that some sound is disturbing, some sort of disturbance. They term it to be a nuisance. Okay, so moving forward, nuisance in air, nuisance, water, some sort, if you are safety, that is public health, all this is a kind of pollution, is a kind of nuisance. Okay,
Creating
it is, sorry.
creating inconvenience to anyone is called nuisance.
Sure. Okay. So any sort of inconvenience, disturbance. So any sort of disturbance is termed to be nuisance. Other aspects, when it is defined in public law, it will take its own course. But any kind, say, for example, recently when I was going through a newspaper, some person, whatsoever reason, he left his car on the mid of highway in Warangal. I came across this in newspaper, and I was going through. So it was the local police has booked him under the nuisance case. So he, for what reason he might have left his vehicle on the mid of a national highway, that is the road, so causing some kind of inconvenience to
To others.
some people. Sorry? Yes?
Inconvenience to others.
Others.
Okay. Okay, others. So probably, yeah. So he has left. So it is a kind of nuisance, unreasonable interference with another person in exercising of his or rights, generally associated with occupation of land or property. So land and property is the aspects which are connected with nuisance. Mostly some person trying to enter your house and chop that tree. Do you think is it a nuisance without your permission?
Yes, sir.
Yes.
Yes?
It's a trespass.
Okay, okay. You see, you have to see. I want you all to give me some live examples where you can better understand the concept. Anyone?
Sir, car parking on roads, sir.
Okay, that is
Creating noise through construction activities in the residential zones.
Okay. So, good. Nuisance.
Unnecessary fighting on the roads causes public nuisance.
Okay.
Drunkards will create.
Yeah.
Excessive light used during rallies and all such activities.
Okay. Okay. So that
Sir,
was.
I think with permission, it cannot come to in nuisance rallies, political rallies.
Okay.
I'm not talking about
A
political,
drunkard.
general values also it can
Okay,
be.
ma'am. Now there was a drunken drive check going on. Some person probably he was sitting. He was on a two. He was along with his friend. The friend was driving. He was not a drunkard, but the person sitting behind drank, and probably he was obstructing. Like he was behaving as if he was not a drunkard, but disturbing, causing some sort of annoyance to the person who was performing his duty. Is this, can we consider this to be a nuisance? See, the
Yes.
Yes, sir. Yes, sir. Yes, sir.
police constable, he was trying to check the person who was driving. But he was arguing with the constable, stating that you check me now. See, I am not driving. So some sort of probably trying to disturb his duty, some sort of inconvenience to that person who was performing his. So they retained him for the whole day in the police station. So this is how things move out. So okay. So if the right is inferred, there is some sort of interference with person belonging as a member in public, the act or omission will be a public nuisance. So, as I told you, the car, when it is left on the national highway, is a kind of obstruction to the other vehicular traffic which is moving. So, it is also a cause of safety, and security concerns. So it is a kind of a public nuisance. And you also have the concept of private nuisance. If those rights relate to ownership or occupation of land or some sort of other easement. You know what are easementary rights? Anyone in the flats, you have the common area?
Yes, sir.
Huh? Okay, if you have an independent house, probably your see, someone owning an independent house and he is not given he is not given some what is it way for his probably sewage, water connection, sunlight. Okay, so all these fall under the easementary rights. Easementary right. Okay, so these becomes a private nuisance. So see, a person beside your house is constructing a huge building and he is not allowing certain that is prescribed sunlight which needs to enter your house. It is a kind of nuisance. Okay. So that is a private nuisance. Okay. So it is
Sir, once
private.
again explain, please. Easement, right, sir?
Easementary, probably sewage, ma'am. The drainage connection is passing through some other property which is not allowing.
Rahul, please mute your mic.
Okay, sir. Thank you.
Some sort of water connection pipeline which is going others.
నలుగురు యూజ్ పెద్దగా ఇదేం లేదే ఎవరు
Ranganath Rahul, please mute
Yeah.
your mic.
Hello.
So he
Hello.
is water correction, probably sunlight. All these fall under easement, some sort of construction disturbance beside your house. If it is trying to cause any sort of damage, then that also you may take it to be a easementary, some sort of easementary rights which the person is causing. So,
Okay, sir. Thank you, sir.
okay. Then you have defamation, or probably defamation we will see probably in the coming, we need to, because it's a big topic. Defamation is also public, that is crime under 499 of IPC and 500 of IPC, where when it is when there is some sort of damage, and okay, trespass. Let us see what the civil trespass and a criminal trespass is. Okay, so for civil trespass is, see, any person, if probably if you have a notice pasted on your probably gate, if you say trespassers will be prosecuted, that is a statutory notice.
Walls and
Is
gates.
it is a notice, not restricting any person. It is private property. Okay, so that forms a civil case. Civil, when he is trying to enter in spite of some sort of statutory notice, he is trying to enter. Sorry, but after entering, he is if he is trying to cause any sort of harm,
Criminal, sir. Criminal nuisance.
uh, that action becomes public wrong when he is entering into, if he's just entering and exiting after that statutory notice, it is a civil wrong. But after entering, if he is trying to perform any damage, any, that is probably it is not his property and he is causing any sort of harm in the form of damage to land or property or individual too, in either maybe either through words or through actions. Okay, that forms a
Sir,
public wrong.
any construction or shed like that also, it will come under criminal, sir.
If see,
Constructing it.
Mr. Escape, how do you establish a liability? Did it fall into your house? Did it harm?
It will be harm, na, sir. If that is my land, if
Harming.
somebody is entering and
See, civil, it's okay, but what is the damage? Injury.
if causes injury, then only it will comes under criminal, sir. If
Public wrong.
they are creating shed, it will not come under criminal, sir.
No. You read, see, what is the ingredients given? See, when you talk about a public wrong, crime, you have to go through IPC. What is clearly defined in that? See,
Okay, sir.
for example, now we are talking about criminal trespass. Okay, trespass in IPC. What does that 441 section speak about? Section 441 of Indian Penal Code, whoever enters into property in possession of another, so another's property, if anyone is entering with an intent, there should be some sort of intention to commit offense, that is, do something wrong, okay, intimidate, insult or annoy. Insult, annoyance, any in possession of property having lawfully entered into such. What can be annoyance? If you break something, you are causing some sort of annoyance. If you are insulting, I said words, through words, even through words, if you are insulting, intimidate. What do you mean by intimidate? You enter his property, warn him, criminal intimidation 506. Threaten him, I will kill you, I will hurt you, or some other language, then such intimidations are also forming a part of public wrong. Okay, no trespassing. Okay, all these are some sort of criminal trespass. Okay, trespassing, someone entering your property forcefully, private, that is even your plot. Yes, you see the boards, right? Trespassers will be prosecuted. Okay, so that is the, okay. With this, I will stop the lecture. We will see in the next class about what it is. Okay. Anyone, any doubts?
Yes, sir. One question here on the nuisance topic. We know for any public nuisances, cases are booked. But if there is any nuisance to only a individual, which we may call it as a private nuisance, can he also book a case? Private nuisance.
Sorry, I put it on mute. Mute. Sorry.
Okay, no problem.
Okay, but this, you have nuisance IPC cases. That is probably in 268 of IPC nuisance. Even yes, you can book because if it is affecting health, life, and causing injury, yes, absolutely.
Even for a single individual person, is it?
Individual, you can directly book. See, for the sound nuisance, as I told you, beyond 20 lbs, you can, the concerned ACP, Assistant Commissioner of Police, will be the investigation officer to conduct. Any damage to environment are now considered to be serious.
Okay.
So all those aspects will come into
Nuisance only.
Yeah, absolutely. The public nuisance, where you are talking about public nuisance, yeah. When we talk about private, it is individual. Individuals, you can even go for damages.
Okay. Okay. Thank you.
So, okay. There is one famous case, that is, one moment, Benoit versus. So,
So Chief Justice in Connolly versus South of Ireland.
okay, not international probably. Let us put more national.
Yeah.
Okay, so the
సార్ ఇట్లా ప్రైవేట్ న్యూసెన్స్ లో స్టిల్ ఒక కేసు నడుస్తుంది సార్ సికింద్రాబాద్ కోర్టులో.
ఏంటండి?
ఈ ప్రైవేట్ న్యూసెన్స్ కింద ఇట్లా ట్రెస్ పాస్ అయ్యి వాళ్ళు కారు దాంట్లో పెట్టి వీళ్ళ ల్యాండ్ లో పెట్టి కేసు స్టిల్ నడుస్తుంది సార్ సికింద్రాబాద్ కోర్టులో ఒక కేసు ఇట్లా.
అలాగే అంటే యూజువలీ అదే అంటే రియాలిటీ మ్యామ్. ఎస్, మీరు తీసుకొచ్చిన కాన్సెప్ట్ రియల్ కాన్సెప్ట్. దట్ ఈజ్ ఇంకొకటి మేజర్ వచ్చేసి మీకు ల్యాండ్ మార్క్ కేసు వచ్చి మన ఒక చర్చ్ లౌడ్ స్పీకర్స్ చాలా
న్యూసెన్స్ క్రియేట్ చేసి
న్యూసెన్స్ క్రియేట్ చేస్తున్నాయని. అంటే ముందు ఓల్డ్ పీరియడ్స్ లో అది అంటే అప్పుడు లాంగ్ ఉండేవి స్పీకర్. సో ఆ స్పీకర్ సౌండ్ ఎక్కువ ఉండేది.
Sir, can you please speak in English?
ఓకే, సో దే వేర్ లాంగ్ స్పీకర్స్ డ్యూరింగ్ దట్ our conventional time when we had so Church of Gods. Okay, this is a landmark case it connected with probably nuisance. Okay, Gods, Church of Gods versus KKR Majestic Colony Welfare Association.
సార్ నేను చెప్పిన కేసులో లాయరే ఎంటర్ ఇంటూ ట్రెస్ పాస్ చేశారు సార్.
Okay, lawyer and
లాయర్ ఇట్ సెల్ఫ్ ఎంటర్ అండ్ ట్రెస్ పాస్ ది నైబరింగ్ ల్యాండ్ సార్.
okay.
Association.
So this is a major case law where you find on probably with regards to some sort of sound nuisance.
That Church of God in India versus KKR Majestic Colony Welfare Association.
I could not hear properly.
Sir, Church of God in India versus KKR Majestic Colony Welfare Association.
KKR Majestic Colony. Yeah, this is a landmark judgment. So hence, just go through this. You will know how it moves about. Okay then. Probably with this, I'll stop. I'm done.
ఓకే సార్, థ్యాంక్ యూ.
Thank you all. Thank you all.
Thank you, sir.